Hey guys, you may have heard the term office action when it comes to patents. So this video is going to completely explain what office actions are, and will actually even give you some bonus tips on how to handle them. So if you're new to the channel, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So in my practice as a patent attorney, I work with Fortune 100 companies, startups, and Shark Tank businesses. And this channel gives you an idea of how I help those folks protect their ideas and inventions. It gives you all the insider information. So be sure to subscribe to the channel, hit that little bell icon so you get notifications of when new videos come out. All right, let's go ahead and get right into it. So when it comes to office actions, what are they? So office actions are related to the patent examination process. And it makes sense to kind of step back and talk about patent examination and what that is and where office actions fit into that. So patent examination, here's kind of the whole rundown. So you draft and file a non-provisional patent application and file that non-provisional patent application at the United States Patent and Trademark Office. It'll sit in line for anywhere from 1 to 3 years. Yeah, I know that's a long time, but hey, it's the government. They're super backlogged on stuff. So the non-provisional sits in line for 1 to 3 years, and a patent examiner finally picks it up and will do, kind of do the basic processing, and what they're going to be doing mostly is determining whether the claims as filed are new and non-obvious compared to the prior art that's already out there. And so when I talk about prior art can be really any technology disclosure. I would say 95% of the time, prior art that is going to be cited against you is going to be issued patent applications or patent publications, but really prior art can be any technology disclosure that occurred before you filed your patent application. It could be YouTube videos like this that disclose technology. It could be a blog post. It could be actual product. It could be like product catalogs. Really any sort of technology disclosure is prior art. So there's a negotiation with the examiner, and hopefully the examiner is convinced that what you have claimed, that the invention you have is new and non-obvious compared to what's already out there, and then will allow the case, you pay an issue fee, and then the application issues as a patent. So what are office actions? So office actions, and maybe let me just step back again. So that you're working with the United States Patent and Trademark Office. So some people would just call it the office. So office actions, they're actions that come from the United States Patent and Trademark Office. And office actions are going to be, they're official mailed documents. So when a patent examiner looks at your patent application, typically there's going to be rejection. Rejections are a natural part of the examination process. And the rejections that a patent examiner is going to assert against your patent application, the patent examiner is going to assert those in an office action. It's the document that the examiner puts in the official record, will mail to you either physical mail or via email, that lays out all the rejections of the prior art rejections or other clarity rejections, things about subject matter rejections. Those are all laid out in what's called the office action. So it's the United States Patent and Trademark Office, and you get an action from them. It's known as an office action. So how do you deal with the rejections in an office action? So starting out the examination process, one of the first things the examiner is going to determine is, do you have more than one invention claimed in the application? And so sometimes this can be as simple as, well, we have a lot of different variations of the invention. The examiner will say, well, these aren't just variations of the same invention. They're actually separate inventions. You have to examine these claims on these two different inventions. You have to examine them separately. That's known as a restriction requirement. So the first office action you may get is what is called a restriction requirement that says you have more than one invention claimed here. You have to select one set of claims to have examined, and you have to then withdraw other ones. So with that, what you have to do is you have to either elect one set of claims to be examined and withdraw the other ones. Potentially you can argue against that. A lot of times arguments, not always successful, or you can potentially amend the claim so that all claims can be examined together. Restriction requirements aren't that big of a deal. So let's say the examiner says you have multiple inventions, you have to withdraw some, you can always file what's called a divisional application. It's a separate patent application that goes after those things that are withdrawn. So don't worry too much about restriction requirements. Talk to your patent attorney about it. It may limit you in some ways, but it doesn't cause that many problems in a lot of ways. So the first substantive office action you get, this will be after a restriction, or sometimes it's the first office action you get if there's not a restriction with issues related to multiple inventions. It's going to lay out, typically, it's going to lay out prior art rejections. Those are the most substantive rejections that I would say 95% of patent applications get. It's going to be prior art rejections. It's, probably almost any application is going to have some semblance of prior art rejections. So we've kind of talked about what prior art is. It's any technology disclosure that occurs before the filing date of your patent application. And there are two types of prior art rejections that are going to be important to understand the difference between. One is a novelty rejection. So with a novelty rejection, the examiner is saying, hey, I found one single piece of prior art, whether that's an issued patent, patent publication, a blog post, or a video, or something like that. This one thing describes everything that's in your invention as claimed. Okay, it's a single reference cited against your claims. So how do you respond to that? All right, so you have a couple of things you can do. One is you can amend the claims to differentiate over the prior art, or you can argue against rejection. So arguing would be saying, hey, examiner, you didn't really understand the prior art. You kind of misinterpreted it compared to our claims, or you didn't really fully understand our claims. That's not what the prior art is saying. It's doing something different. You can make arguments, or you can amend the claims. You can add elements that the prior art doesn't show. So for instance, let's say the prior art talks about elements A, B, C, and D. If you add element E to the claims and element E is not talked about in the claims at all, it's not talked about in the prior art at all, you can get over that novelty rejection. Okay, that leads us then to the second type of major rejection, which is a obviousness rejection. So obviousness rejections relate to typically more than one piece of prior art. And what the examiner is saying in an obvious rejection, it would be obvious to come to your invention based on one or more piece of prior art. It would be obvious to one of ordinary skill in the art, that being your average person who works in the field of the technology. It would be obvious to them to reach your claimed invention based on all the prior art that's out there. Sometimes this can be 2 references. Sometimes it can be 3 or 4 or 5. I've seen, 10-something references cited against claims in a patent application at times. A lot of times, patent examiners don't like to cite a lot of prior art because one of the arguments against an obviousness rejection is that, well, it wouldn't be obvious to combine all these things. Would it really be obvious, to combine all these 10 references and pull all these pieces from, all these 10 references to come to the exact claims that we have? Maybe not, right? There's no official, nothing official at the USPTO that says, hey, you can't use 100 references to reject things. But a lot of times, examiners don't like to use a ton of references for obviousness rejections. But so as far as obviousness rejections go, you have the same options to address them as with the novelty rejections. You can amend the claims or you can argue against the rejection. Same thing. You can say, examiner, you didn't really understand one or more of these pieces of prior art. It doesn't really teach what you're saying it teaches. It doesn't teach all the elements of our claims. Or what you can do is you can amend the claims and add something that isn't taught in any of the pieces of prior art. That's another way to get over the obviousness rejection. Another way you can get over it is, like I said, you can say that, well, it wouldn't be obvious to combine these references. Those can be difficult arguments in a lot of ways. There has to be really special cases. It would have to be, say, very different fields where it wouldn't be obvious to somebody to look in this field and combine it with something in this really completely disparate field. Sometimes those sort of arguments can work, but usually amending the claims or arguing, those tend to be the best way of getting over obviousness rejections. So hopefully, you are able to get over all the rejections and you get the patent issued. The examiner will allow the case, you pay an issue fee, and then it issues. So with the office actions, how many of these are you going to get during the examination process? Well, it totally depends. In very rare cases, you'll get a notice of allowance immediately. Your first office action is the notice of allowance. The examiner says, hey, everything is totally allowable. But that's actually not a good thing and not common, which is surprising to a lot of people. it should be like a negotiation. Think about, for instance, like shows like Pawn Stars or American Pickers. It would be a boring show if every single deal somebody said, hey, I'll give you $100 for it. And they're like, yep, I'll take $100. Yep, I'll take $150. Yep, I'll take $25. Wouldn't make for a very good show. And it's just not the way that business is conducted. Usually there's a negotiation. Right? The buyer starts off with a low price, the seller starts off with a high price, and then they kind of meet in the middle. That's how patent examination is, right? So the applicant, the person with the invention filing the patent application, they start off with broad claims, going after a lot of patent protection, okay? And the examiner then, it has to kind of reel them in and say, well, you're not quite entitled to that because of the prior art. That's the negotiation. So that's why in the negotiation of examination, rejections are to be expected and are actually good, because think about, for instance, if you are offering somebody, you're haggling with somebody over something, you say, hey, I'll give you $100 for it, and they immediately like, yes, I'll take it. Well, the first thing you think is, well, oh man, I should have offered less. They were too eager, right? Same thing with patent applications. You almost want to set it up and go in with claims that are a bit too broad and let the patent examiner whittle them down a little bit so you get the best deal, as in you get the broadest protection possible, just barely getting over that hurdle of patentability. But there definitely is an art to not dragging out the patent examination process too long. That is not a good thing either. One is it's really expensive. Every time you have to respond to an office action, that's attorney time, and that ends up really adding up. Two, the optics of it aren't good. It doesn't look good to investors and other folks to say, well, this patent application has been rejected 8 times. It makes it somehow seem like, well, maybe this isn't going to be patentable, maybe it's not going to work, or maybe the invention isn't good. It just doesn't look good. That's not the case. Sometimes examination, it takes forever. Maybe it's a really hard negotiation, and you're sort of incrementally having to work your way towards a middle ground with the examiner. Or sometimes you get a bad examiner and they have bad rejections and you have to fight them. They don't understand the invention. A lot of examiners, they don't have enough time to really examine things appropriately and to fully understand invention, so sometimes that can make things take a long time. But that's one of the reasons why using a patent attorney is really important. The patent attorney will typically set up examination, so ideally you don't have to go back and forth with the examiner too many times. I would say on average, probably 2 or 3 times back and forth with the examiner. So you get, say 2 or 3 substantive office actions. That tends to be the average. And that's where I like to keep things. That's where you get a good balance of getting a good negotiation where you get good quality claims, but not spending way too much money having to unnecessarily go back and forth way too many times and argue about things that are less important. You can always go after those other inventions or broader claims in what's called a divisional or continuation application. But that's for another video. So that's what office actions are. Thanks for watching, and I'd love to hear your comments about it. Like, is there anything that I left out? Does anything not make sense? Do you have any additional questions about office actions or responding to office actions? Let me know down in the comments below. I'd really appreciate hearing what you think. And if you got any value out of this, give the video a thumbs up. We'd appreciate it. And if you want more information about startups, about patents, be sure to subscribe, hit that little bell icon so you get notifications. And yeah, thanks again for watching. We will see you again in the next video. Cheers.